Okay, hello everyone, and so sorry about the delay in getting started. Just to kind of let you know what happened, the town of which I live in, where we are streaming from, the entire town just had a power outage. So, so I hopped in my car and drove around until I could find a spot with some connection. So it looks like we're on. Sorry for the delay in getting started. We're really delighted to have you all with us. So anyway, my name is Jody Williams. I am the Indigenous Education Lead here for Dufferin Peel Catholic, and it's my privilege to be having this conversation with Deahande today. And I'm just going to screen share something so that you can see here, just to bring a little context to this conversation, if it is even possible. Just one second, because also I would normally be operating out of 3 screens, and now I'm in my car on a laptop, if you can appreciate that. So give me 1 second here as I toggle between screens. So this map that I'm showing you here is just to provide some context. Sorry if it's a very small image. See if I can bring it out a little bigger for you. This map is to bring some context in terms of the conversation that we're having today. It's the last day of Treaties Recognition Week, which, we encourage you, don't end the conversation today. This is just a beginning. Hopefully you'll continue to have this learning going on. But we're going to be talking a little bit about what's been coined hashtag 1492 Land Back Lane. And so what you're looking at here is in the green there is what's known as the Haldeman Track. And the little orange area there is where Six Nations Reserve is, and that's where Deahande is tuning in from. And I'm going to turn it over to him now. He's going to give a formal introduction, but I just wanted to share this image so you had a bit of a context to where this discussion is taking place with respect to Caledonia. We will do our best. I know we're starting a lot late today, but this is going to be recorded, and we'll do our best to try and get to your questions as they come up in the chat box through the stream. But if we can't, we apologize for that, because we have a lot of important information that's going to be shared today with Deahande. And hopefully this will, get yourselves thinking and learning about what's happening, but we really want to encourage you all to move your learning into action. So think about ways that you can actually get involved as a call to action to end a lot of the injustices that continue to happen today across these lands, directly related to violations with respect to treaties and Indigenous peoples. So without that, without any more from me, I'm going to turn it over to Deahande now.
Okay. Sego wego Deahande ni waxanoda o swego zinu tkiderum waginyata da no Kanyen'keha, which is my introduction. I'm known as Deahande. I live at Six Nations and I'm of the Turtle Clan and what's known as Mohawk Nation. And so living on the territory of Six Nations. And so Caledonia is just on our back doorstep. And the lands that are in dispute are and I don't even like the word dispute, but the fact is it's the issue right now. And we're looking at a background understanding. So I'm gonna share a slides with you. And so let's hope that this becomes visible. So I'm going to put that up right now. And so we're talking about Caledonia here. And like I said, land dispute. And this area that we're talking about is better known in our area here as Plank Road, which is right across the road from the meadows that called Mackenzie Meadows. And so I trust everyone can see that. And so what I've started out with is I've started out with a timeline, because the timeline gives us a perspective onto the events that lead up to this situation that we have right now. And I'm not good with dates, so that's why I did the timeline here. And I can understand things a little bit better when I see a timeline, because then I can put things in perspective, and hopefully everybody is the same. So at the beginning, it's 1775 to 83. Six Nations ally with the British during the American Revolution, and losing a significant piece of territory in present-day New York as a result. And so the 1984 Sir Frederick Haldimand, governor of Quebec, grants 95,000 acres acquired by treaty from the Mississauga to the Six Nations as a settlement 6 miles deep from either side of the Grand River. And it's commonly called the Haldimand Tract. And that was that map that you saw earlier. In 1793, Haudenosaunee leaders say that Haldimand Proclamation grants them free hold title to the land. And the Crown disagrees with that. Lieutenant Governor of Upper Canada, John Graves Simcoe, issues a patent upholding the proclamation. And that was about 2 years after the original grant. And but the patent does not include the Grand River headwaters, reducing the territory size almost in half. Early in the 1800s, a Mohawk leader known as Kanyen'keha, English name Joseph Brant, authorizes a sale and lease of some parcels. Many settlers are squatters. Six Nations petitioned the Crown and asked for their removal. So because the territory was so spread out, we didn't have the population to be able to be on the entire territory watching out who was moving in. So there were constantly squatters approaching on the land. In 1830s, the Crown approaches Six Nations to build what's called Plank Road. And as I mentioned, this Plank Road is the same territory that is in dispute right now and is in the news. Through Six Nations agrees to lease this land. The Plank Road later becomes known as Argyle Street and Highway 6 in Caledonia, where several blockades and protests occur throughout the 21st century. In 1835, founding figure Ronald McKinnon arrives along the Grand River Navigation Company in future Caledonia, squatting on Haldimand Tract increases. In 1841, Samuel Jarvis, Chief Superintendent of Indian Affairs, tells the Six Nations that the Crown will not forcibly evict 2,000 squatters. Caledonia's population is about 300 at that time. So just so everyone knows, we're going to be able to provide these slides for further verification, because each one of these dates has a history all of its own. So if you want to go deeper into it, you may do that. The Crown obtains the disputed general surrender. Under those terms, after 6 chiefs sign the document, 51 chiefs and warriors protest the surrender a month later, saying Jarvis coerced or manipulated those who signed. In 1850, the Crown, which is basically the government of the day, a proclamation settling the Six Nations Reserve at its current size, approximately 47,000 acres, or less than 5% of the original size stated in the Haldeman Tract. In 1853, the Crown sells the future Mackenzie Meadows, and that's the area that's being occupied right now, lands to Thomas Nichols. And the grant explains that the parcel in Ontario Township is Six Nations Reserve, and that the proceeds will go to Six Nations. In 1923, Descahe, who was a Cayuga hereditary chief, travels through Europe seeking international recognition for the Haudenosaunee. And a year later, RCMP in 1924 deposed the traditional government of Six Nations and installed an Indian Act elective system. The police seized wampums and locked the chiefs out of their council hall. Following that, in 1927, government makes it illegal for bands under the Indian Act to hire lawyers to advance legal claims against Canada. And that's really important to understand, that they realized that we had a case and they blocked it. In 1959, RCMP quash a revolt by hereditary chiefs who attempt to reinstate traditional government. So that's been tried. 1980 to 95, the Six Nations launched 29 land claims against the Crown. Claim number 5 includes the Douglas Creek Estates land, which is across the road from the current reclamation. And it was reclaimed in 2006. Claim number 16 is the former Oneida Township, which includes Mackenzie Meadows. So it's need to understand that Douglas Creek occurred in 2006 and Mackenzie Meadows is right across the road. The Crown closes all claims after the Six Nations sued Canada and Ontario for an accounting of all cash, land, or assets owed as a result of alleged misleading along the Grand River. In 2003, a developer submits a draft subdivision plan for Mackenzie Meadows. And in 04 and 05, Six Nations paused their lawsuit to explore negotiations with Canada and Ontario. And that's really important to note, because we've been opposing this for a very long time, even though the Crown insists that we haven't. Six Nations people in 2006 occupied the Douglas Creek Estates, known as DCE subdivision, renaming it Ganastadu, and it's Mohawk for the protected place. It becomes one of the largest, most expensive, and bitterest First Nations land occupation in Canada's history, marked by violent police raid and clashes between Six Nations people and Caledonians. Ontario then buys the land from Simcoe Industries to cool tensions, because that was the developer. And the land remains in Ontario's name, held in trust. 2007 and 8, Canada, Ontario, and Six Nations hold talks on the conflict. The traditional system, the Haudenosaunee Confederacy Chiefs, also known as HCCC, leads the way. In 2009, the talks sputter. The Six Nations reactivate their accounting claim led by the elect council. A trial is scheduled for October 2022, the council says. 2013 and 14, direct action protests, blockades, and occupations resume. The Confederacy constructs a large gate emblazoned with purple and white Haudenosaunee flags across it, the entire entrance of Ganastadu. Community consultation rejects Mackenzie Meadows project. Elect council decides not to support it. 2015, Mackenzie Meadows developer Foxgate Development acquires land from a numbered company. And on July 19th this year, Six Nations member occupy a construction site at 1535 Mackenzie Road, renaming it 1492 Landback Lane. And that's what you see in the news today. The subdivision across town, but linked to Gunnersdale through a hydro pipeline easement road. On July 30th, Foxgate Development obtains an injunction ordering the camp dismantled. On August 5th, the Ontario Provincial Police enforced the injunction, and police use a taser and rubber bullets to clear the property. I'm going to skip a few of these things because you can look out these individual dates according to when you receive your information sheet. And on August 22, the last of the main blockades outside Gunnersdale is removed because we were trying to appease everybody by opening up the roads. The court extends both injunctions. Spokesperson for the action, Skylar Williams, is defined as a protest leader and named on the injunction. So September 16th, the arrest continues. OPP released the names of 22 people charged. And on the blockades, on October 9, the court extends injunctions again. Police affidavit says police are wary of removing camp occupants the second time, calling the force a blunt instrument that cannot resolve the issue underlying land disputes of this nature. Harper, who is the judge, gives Williams, who is self-represented in court, an ultimatum. And he tells him to dismantle the camp and be allowed to participate in future court hearings. Or if he decides to flout the order, to be prevented himself from attending court. That's all. This timeline is taken from the APTN report, October 2020. The background on this is we have to understand that there's 2 points of view. And that 2 points of view is basically how Western thought or colonial thought considers land. And the native view on land is much, much different. Ours is more a relationship with the land. And so we have a very, very deep tie to the land because we're all people of the land and we need the land to survive. Not like anybody else. The colonial view is basically the land is a resource. The land is to be bought and sold. And the Canadian government still, in fact, relies on what's called the doctrines of discovery, claiming that they have obtained underlying title to the land. And that in itself is very problematic because to have the government look at our side, we're not in agreement as to how we view lands. And the Royal Commission on Aboriginal People put out this statement, and it's a very accurate statement. It says the original peoples have not been simply the passive victims in this process. They have used any means at their disposal to halt the relentless shrinkage of their land base from an original Aboriginal perspective. Treaties were one means to that end, but Aboriginal people insist that the Crown has failed to uphold these agreements and has generally broken faith with them. And since the 19th century, they have continuously protested to government officials, to parliamentary inquiries and the courts. And what they see as the resulting inequity in the distribution of lands and resource in this community, conflict over land and resource remains the principal source of friction and relations between Aboriginal and other Canadians. If that friction is not resolved, the situation can only get worse. And so we look at the Trudeau leadership, and they put together this what's called specific claims resolution policy. And initially, if we look at that and we see what their how they set this out, it's under this federal policy. And it talks about breaches and obligation of the Crown. And so these specific claims give rise to negotiation and compensation. And what we need to understand is what they're talking about when they talk about it in that way. And so with these concepts in mind, we must make ourselves aware of the language being used by the government, specifically the words specific claims policy, which means the extinguishment of our rights as original people given by creation. Under these words, which are the Canadian words, we no longer exist as Ungwehui, or in other words, real people, allies to the Crown, but we become subjugated to the lowest form of citizen in Canada without equal rights compared to other subjects. And what I mean by subjects is other Canadians. Basically, it's the same agenda as the White Paper of 1969, which is extinguishment of rights. And all of that you can look up on the net. And it's really good research to go into. So there's a little bit about the White Paper. It's just some quick points. It eliminates Indian status. It dissolves the Department of Indian Affairs. It abolishes the Indian Act, and that all sounds good. It converts reserve land to private land that can be sold by the band or its members. It can transfer responsibility for Indian affairs from the federal government to the province and integrate these services into those provided to other Canadian citizens. And the bottom line here is that it extinguishes all our rights to the lands and any agreements that we'd made under that. Let's remember what lawful obligation means. And these are the words set forth by the Trudeau government. A breach of an obligation arising out of government administration of Indian funds or other assets. And you need to understand that the government has been holding on to our assets for a very long time, and they've not been forthwith in giving us a proper accounting of what they're doing with Indian monies, we call it. So I don't even like to use the word Indian, but that's their language. More facts. So in 2006, when we had the conflict on the other side of the road, the government, the Canadian government, actually asked Michael Coyle, who is a fact finder, to make recommendations. And so he does just that. And it should be noted that in many cases, no surrender was actually made, as in the case of the purported 1841 surrender. It was bribery and duress under potential factors. Furthermore, their purported 1841 surrender does not meet the requirements of lawful alienation of Indian lands, which means the Royal Proclamation, and you can look that up on the net as well, states a number of things. And it states that the land could only be granted if the lands were surrendered or ceded by the Indians to the Crown. So in other words, it's not a legal sale unless the Crown gets it first. And that was set up way back in 1763. And that's Canadian law. And that law is still in effect today under the new Constitution. And A, Indian lands could only be granted if the land were surrendered or ceded by the Indians to the Crown. B, colonial governments could not grant unceded Indian lands. Remember, unceded Indian lands. Private persons could not settle on unceded Indian lands, even though they did. Private persons could not possess or own unceded Indian lands. And that's right in this findings. Private persons could not purchase unceded lands from Indians. The Royal Proclamation was never repealed. And that's really important to know, that this is still law in Canada and binds what's known as the Canadian and Ontario governments as the Crown. Now, we received this land in 1784, and it defines that area that you saw in the map there. And it is called that Grand River, is the river that runs down the middle of that. And it was granted that 6 miles on either side. And at the end of it, it says, in this Majesty's name authorizes and permits said Mohawk Nation and such as others of the Six Nations Indians as wish to settle in that quarter to take possession of the settle upon the banks of the Grand River called Ouze or Grand River running into Lake Erie, allotting them for that purpose 6 miles deep from either side of the river, beginning at Lake Erie and existing in that proportion to the head of the said river, which them and their posterity are to enjoy forever. And shortly thereafter, in 1793, the Simcoe Patent, following the terms, are set out. 1, Six Nations could not alienate any of their lands except by surrender to the Crown. Again, it's repeating the same thing as the proclamation. At a public meeting of the chiefs, warriors, and people of the Six Nations. And it's important to remember that we, according to Canadian law even, cannot surrender lands except to the Crown. And it has to be in a public meeting. The chiefs have to be there, the warriors have to be there, and the people have to be there. And it has to be in public. Six Nations could not sell, gift, or exchange lands with other members of Six Nations, but not to non-Six Nations people, unless there was first a surrender to the Crown. Six Nations people were to enjoy free and undisturbed ownership of the lands noted in the Simcoe Patent under the protection of the Crown. In reference to Plank Road, now known as 1492 Landback Lane, which is in the Oneida Township, there are no government records of deposit to Indian trust funds from the Crown on this alleged surrender, which means that if this land had been sold to the Crown failed to put it into the trust funds. So it's a breach. In court documents, and I'm just going to skip down to the middle of that statement. In court documents, and this has to do with the injunction that was placed, Foxgate the developer of Mackenzie Meadows, argued that the land was no longer Haudenosaunee territory because it had been sold to a private buyer in 1853 by a Canadian Indian agent. And so we can only assume that they're talking about the Crown, an officer of the federal government of the day and not a representative of Haudenosaunee. And that, if you're looking for it, came out of the Standard, and that's Friday, September 4th, 2020. And so we have to consider what that means. And so we're jumping to the end of that statement. It says, the Superior Court of Justice ordered an amicus to clarify the matter, and is a court file number, and that's the court file number if anybody's going to look that up. It states, the AMICUS report states, and we're referring back to this 1841 surrender and another 1844 surrender. So there's two surrenders that the government used to state that these lands were sold. Professor Johnson does not accept an instrument dated January 18, 1841 as a demonstration of a valid surrender, because there is no evidence to whether this instrument was ever approved by order in council. And each one of these statements has a reference number to look up. Under section 113, it says that the validity of the 1841 surrender is not determinative, since the experts appear to be in agreement that if the lands were surrendered in 1841, any ostensible surrender was rescinded on October 4th, 1843. Now we're going to council meeting 1844. Again, December 13, the minutes indicate the position to surrender lands in question was previously put to Six Nations at the meeting. On these dates, the Six Nations failed to agree to surrender these lands. In section 120 of that report, it says there is no evidence at all that all the chiefs or warriors or women, as required by the Simcoe Patent, agreed to a surrender. In section 124, there was no deal between the Crown and the Six Nations on December 18, 1844, with respect to surrender of lands. On cross-examination, Miss Holmes agreed, and this Miss Holmes is also expert witness. In section 130, this court on 3 prior occasions, October 17, 24, and 31, in 1844, the Six Nations refused to surrender the lands in dispute. So now we're back and we go over looking at what's going on here now at 1492, or what's become known as 1492 Landback Lane. Is Mackenzie, it's called Mackenzie Meadows. So it's on the Haldeman Tract and it's in Oneida Township. And here's where squatters were moving in various areas of Haldeman Tract, including the area that is presently under debate. According to squatters' rights being recognized at that time, there was a requirement to occupy the land for a period of 10 years or more. The squatter who occupied this piece of land sold the land to a Nichols family, having only occupied the land for 6 years. So right there, were in their breach of their own law. Canada is in breach of its own law right there. The Nichols, who had friends working in land registry, together called upon the Crown to issue them a title for the land. And the Crown granted the petition, according to records and various correspondence. So here's a statement that came out of back across the street, Douglas Creek, in around 2006. And it has been said, hopefully, it will be the last time our people will have to go through anything like this. The message to Canada is that it must now deal with the issue of our land and the trust fund that they have never been accountable for. It must honor our treaties, accept responsibility for its own abuses against our people, and deal with the theft of our land and resources and righting the wrongs in an acceptable time frame. The land claim process designed by the government through the Department of Indian Affairs is a scam. The whole process is designed not to protect our interest in the land, but to continue to sell land that they deem surplus Crown land, meaning any land that belongs to our people that they want to or can use or sell. And nowhere in the process is it ever intended to return the land. They only want to get out the checkbook, and it is usually that after development. There is no acceptable and must, this is no longer acceptable and must be stopped. And this was by a well-known protector of the land. Final thoughts on this. You know, considering this information personally, and this is my view on it, I would conclude that the land was not sold and that the sordid matter of the squatter sale to a third party is not a valid sale, morally or legally. It seems to me a thin argument to use to dispose land, and that the court is using this argument to legitimize an injunction and criminalize defenders of the land. And this is still afterthoughts in the sense of what we're facing right now, that the federal government needs to follow its own laws and respond in good faith to restore what they call the honor of the Crown. And I would also conclude that we as a community, and right now I'm really encouraging our community, should first petition our chiefs and our clan mothers, along with the elect band council, to insist that a moratorium on all commercial development be placed on lands that are coming into litigation. I have been told that the accounting litigation of 1995 is scheduled to be heard in 2022. What that would do, what a moratorium would do, would remove the threat of being arrested, because right now our people are being arrested as soon as they attempt to leave the property. And if there was a moratorium, we could repair the damaged roads and railways, and our neighbors, who are being inconvenienced right now, could be, their minds could be set at ease, because that would remove the threat of roadblocks, and it would really give everybody time to think about this and look for a solution while this is under no development. Furthermore, in our way of looking at things, we have a constitution that overrides actually Canadian Constitution. It's a world law that any constitution who is already in existence, there's no other institution or constitution that can come along and overwrite it. So we have precedent in that way, and we call it Kanyen'keha. And that Kanyen'keha states that when the leadership of the community is not carrying out the wishes of the community, then it's up to the community to take action on their own, which is basically what's happened here. And so we're in this state right now, trying to look for a resolution. And this is, now I'm going to leave it to questions, because this is just a quick overview of the kind of history that we're looking at right now. So I'm going to stop the share here and go back to our regular screen. So if there are comments in the comments section, I can address those. And if anybody wants to know more about it, I have plenty of other information, and I can clear up any understanding that you may have about what's going on right now. So hopefully we're still live streaming. So I don't know if we are. So here we go.
We are still live streaming. Yes, we are. So
good. Are there?
Yeah, we will. So if you want, so if the people that are listening in, if you want to put your questions in the chat box, we will help to moderate those. But maybe just something, because it's complicated information when it's the first time people are hearing this. And I think maybe just to reiterate some of the stuff that you had mentioned, that I want people to really focus in on, is that Canada, and by extension of Canada, Ontario, is breaking its own laws. That's very important for people to realize. And so when we go, and I want people to also consider that when there's a discrepancy or a challenge that to address when your human rights are being infringed upon, or that there's there's a violation happening. And in this case, when we talk about nation to nation, so when we talk about if we're going to refer to Canada as a nation, and the Confederacy comprised of several nations, then if Canada is the perpetrator, just the notion of having to take Canada to court in Canada's court system is also, that's problematic. So think about that. If somebody has, violated you, and the only legal mechanism to address that is to go to that person's own justice system, that's also an issue. So I think it's important that when we're talking about these things, that these are land issues that go way back, and we're always going to have these conflicts coming up, because we're not ever addressing the root problem, which is getting at the fact that lands have been illegally stolen, occupied, or taken away from. And we also have legal agreements still in place on the books that are to ensure that those Indigenous nations that have those rights to those lands needs to be upheld and adhered to. So one of the things I would like you to maybe go in on a little bit is understanding when we hear the term band council and chief and council, and also when you talk about hereditary chiefs, clan mothers, because I think that's a piece that people don't understand, is that part of colonization and part of the the tactics that have been used on these lands through legislation has been to dismantle and disempower our governing structures, our original governing structures, and impose this band council system. And the band council, the job is to administer the Indian Act on its own people, and therefore are also, by extension, employees of the Canadian government in that sense. So it sets up this huge conflict of interest, if you want to call it that. And I think so people have to, I think, spend some time unpacking that, even to understand the implications of what band council, when there's a band council that's making decisions on behalf of the people, and those things. So if you want to unpack that a little bit.
So while you're unpacking that little piece of information, you also have to realize that our community, we have a population of 27,000. And when we're talking about an imposed elect system, that is the extension of the Canadian government. And also it's the view of the courts that they will only recognize the elect council as being the proper party with authority to deal on these matters. And the fact is, it only represents a very, with only 1,900 votes for 12 elect council members. It's, what is that? You know, that's a little over 10% of the population. It's not a true representation of what the people think. As a matter of fact, many of our people here at Six Nations say that the elect council doesn't speak for me. And because we didn't vote them in. It was only a very, very small majority, it's not even a majority, a very, very small percentage of the people who did vote them in. Our traditional council, again, has more support than the elect council. So we actually have the two councils, and it's really important that they work together and carry out the wishes of the people. And so as the people who have this as their leadership, it's really important because of our Constitution. And what I mean by that is our traditional way of governing ourselves. It's the people that decide. It's a true democracy. It's the people that tell the leaders what they want done. And so that's why I say in my summation there that if the two councils aren't working together to get this a moratorium put on development, then we're going to continue to see these outbreaks because it's not being dealt with. And so that's the kind of political environment where we're being subjected to, and not really proper, that the majority of the people are not being heard. And that's the real sadness of this affair. Are there any questions?
Yeah, and that's also a product of colonialism. Colonialism is meant to divide and conquer, divide up the people so that there's no opportunity for unity, to keep people fighting amongst themselves. So this, this is another, just another part of it. So a question here that's come in is, why do you think that the government today refuses to acknowledge that the land is Haudenosaunee land?
That's got to be the $1 million question, really. I can tell you what I think, and it seems to me the government has a number of times walked out on negotiations, and like I wasn't there, and there are no records that we have. The government has much better record keeping ability. And what I've heard many, many times here at Six Nations and from those people that were there, and they said it was put to the Canadian government, do you have a surrender for these lands? And they admitted they did not have a surrender for the land, which means to me that that's the reason they've walked out of negotiation, is because they don't want to they don't want to deal with it. That's the only conclusion I can think of. Otherwise, that's the kind of thing that you should be asking your leadership, because you're a Canadian citizen. You have the right to approach your government, and you have the right to ask them why. It's maybe because if they look at it, they think they own the land. But if you really look at the records show something very different. As a matter of fact, myself, when I got interested in this kind of in a backwards situation, I was asked to sit on an elders council to discuss what we should do here. And so I started doing my research, and this is what I came up with. From what I see, and from the things that Elect Council, remember Elect Council is part of the federal government. Elect Council here has put out this circular that I didn't see originally. I had to go searching for it. They believe that the lands were sold. And how can they believe the lands were sold when we have written documentation that it was, the sale did occur, yeah, but it was not according to law. And they had not followed neither the recommendations of a legal sale, which has to go back to the Crown. And if it goes back to the Crown, then the Crown has to make payment for the land. Well, there is no record of payment being made either. So how can you say that they own the land when these are what the documentations prove? Because I was in a position of saying, well, I'm not really sure. So that's why I did the research. And the slides that are available here points out the timeline. That's why I did the timeline, because it's very complex in a sense. You have to go through a lot of things to say, okay, now I understand the laws of Canada have not been followed here for a legal sale, and everything just ran from there. And now they're turning around and say, oh, well, we have surrender. Well, if you have surrender, let's look at it. And that's why I pulled out the AMICUS report, because the AMICUS, if you don't know what the AMICUS is, it's a factum. They interview individuals who are recognized experts in the area of documentation. And there's been a number of them. There's been 3 at least on this AMICUS report. And they all point to the fact that these were never surrendered. So very good question. But we need to be asking not just our people, but the Canadian people to approach their leadership and ask those same questions, and know that the documentation is solid. There's a constitutional argument here just to prove that, and it's that constitutional argument is in excess of 600 pages. And again, the courts say, well, it's unsubstantiated. So, you know, how do you proceed when the courts refuse even to look at the papers? They say it's unsubstantiated. So we have an obligation to somehow substantiate it, by how else do you to do it except by correspondence, letters of the day, agreements between people, and observation of what they did. And here we are today in this situation where we know that the land is ours, and still we're being prosecuted and being ejected, and they're using the OPP as their strong arm, like a goon squad, to say, hey, well, the court decided this based on doctrine of discovery, and there's nothing you can do about it. And we beg to differ on that. And if our leadership is not getting anywhere with this, then it's up to the people to do it. What choice do we have?
Yeah. I really want to emphasize there, in case people missed it during your talk, was that, so hopefully by now people are getting to understand why there's occupations going on in terms of reclaiming lands that have been wrongfully taken. But can you imagine now when you are, trying to defend your homeland or your land, and you're being shot at by the police? Like,
Yeah.
this goes on all the time across the entire country. Violence towards Indigenous peoples who, in many cases, like we hear this and see this over and over and over, women who are having their bones broken by police, militarized police, for simply drumming. Like, this goes on and on and on and on. And so part of why we want to bring awareness to this and why we're having these conversations is to make this more publicly aware and encourage you all, and especially as students, to become informed and speak out. Write to your government officials. Demand that there needs to be proper justice, that you're not okay with this happening to human beings, that deserve to be treated with respect, and we have to solve these land pieces. So there's one more question here, and I realize we are out of time, and I apologize for the difficulty getting online. But the question here is the permanent injunction being enforced? What is the situation there now in terms of the occupation?
The occupation, that's why there was a reaction by the defenders. They barricaded themselves because they were afraid of being overrun by the OPP. And so I don't know, it's the OPP, unfortunately, who are in this situation where the judge is pounding his gavel saying, you've got to get out there and you've got to enforce the injunction. And so it's a very dangerous situation now. Everybody is afraid of making any kind of move. And at the same time, this is a potentially volatile situation, because what are the police going to do? They're going to come in there and they're going to be doing the same things they did before. They shot rubber bullets before, not even taking into account who is behind that they were shooting at. And so there were, from a number of accounts of people that were there, they said there was a fire, and it was not even on the site. There was a fire close by, and there were a number of elders sitting around there, and they had literally bullets whizzing over their heads, and they were shocked. They were like anybody would be, and that needs to be addressed too. It's like, how the only thing that I can see at this point that could resolve this is the government's got to step in. The Ontario Provincial Police put a temporary what you call it, a temporary stop to the injunction before. And they did that in 2006 with the Douglas Creek Estates. So they have the ability to put a moratorium on construction for lands that are not going to be dealt with by the courts until 2 years comes down the road. That's what their responsibility should be towards protection of the people, not just to say, okay, OPP, go ahead and do your thing. So I feel really sorry for the OPP to get stuck in such a situation where you got the courts on one side and us on the other side. And it's because of a legitimate situation that this is our land. And that's the gravity of the situation. It's really sad. That's why it's so important to get out to our leadership there that a moratorium has to be placed here, because how else? Because if this doesn't get solved here and they forcibly remove them and they continue on with development, it's going to happen in other places too. So we're not going to see the end of this. It's going to keep on going. And that's the sad reality of it.
So we've come to the end of our time here, and I really hope that those who are listening and watching are thinking about, well, first of all, how can you become more informed? I really want to encourage everyone to keep inquiring. Be very careful as to the source where you go for information. Media can also incite more violence depending on how it's being portrayed. So oftentimes we will see in the media, people protesting and causing, almost like terrorism towards our country, when no, this is about protecting land protectors or land defenders, or people exercising their rights to have an existence here, and land is part of that. So so be careful in terms of where you get information from, but that's a good opportunity as well in education, as in terms of critical literacy skills that we often talk about. And so I just want to thank you again, Deahande, for spending this afternoon with us to talk about this really important issue that needs to be resolved. And I hope that there's more people that will get involved and start to speak out about this. So if there's any closing words that you want to have before we wrap this up, I'll turn it back over to you.
Well, I think it's basically, if we look at this in a moral sense, and in our way of thinking, we don't even have a word for justice. We say something is either proper or correct. And I don't think that this situation that's going on now, and that has been going on for a very, very long time, fits into either of those categories. It's not proper and it's not correct, morally or even legally. And that would be my contribution to this, and saying this is the thing that we need to all work on together. And with your help, any way that we can move forward is so much appreciated. If you can support in any way that you think you can, or even if it's a limited way, like maybe writing a letter, let your thoughts be known. And this way we can build a stronger unity between all people in Canada, and we can all be proud to be on this continent. Tukniego.
Thank you very much again. And we will follow up with an email. Deahande had mentioned he's going to make his slides available. And I'll add in there a few other links in terms of where to go to get information, or for supports. There's lots of even financial donations they're looking for as well. So we'll follow up in an email for that. And I just want to thank everyone for tuning in today and listening to this very important conversation. So thank you again. Have a good rest of your day. Stay safe, and hopefully we'll see you on the next one. Bye-bye, everyone.